Welcome to Ducks in a Row, the Estate Planning Guide.
Welcome to Ducks in a Row, the Estate Planning Guide with attorney Erin Nunes, one of the managing partners at Surprenant, Beneski and Nunes, estate planning and elder law. Erin and her team of dedicated legal professionals are helping southeastern Massachusetts families plan for tomorrow, today. I'm Evan Mack, and today we're talking about the key documents that make up an estate plan in Massachusetts and how to know what actually applies to your situation. Ms. Erin, welcome.
Thank you so much for having me.
So, Erin, when someone comes in without a plan, what are the main documents you're typically talking through with them?
So really at the heart of any good estate plan are what we refer to as your foundational documents. These are the documents that are critical to have whether you have $5,000 in the bank or you have $5 million in the bank. They're the documents that allow you to choose who you trust to step in for you, make legal and financial decisions, make medical decisions, have access to your protected medical information. In the event that, something happens to you, a accident or an illness where you cannot make those decisions for yourself. So that's really our starting point, because a lot of people don't realize how critically important those documents are.
So what does a will control and what doesn't it cover on its own?
There's a really big misunderstanding out there that if you have a will, it means your family's not going to have to go through probate.
Wow.
And that's just unfortunately not accurate. So your will controls any assets that you own individually when you pass away. So if yours is the only name on your home, on your car, on your bank account, so just, Sally Doe, full stop, no joint owners, no beneficiaries, no trust in place, just her as an individual. The way that those assets get to your intended beneficiaries is through the probate court process in Massachusetts. And your will acts as the instruction to the court as to how you want those assets to be distributed and who you would like to represent the estate and have the power to pay final expenses and make those distributions. That role used to be called an executor. Now it's called a personal representative. So the will really only controls assets that you own just in your name alone when you pass away.
So where do trusts come into the picture? And what situations tend to make them useful?
So when someone comes in, we really kind of do a deep dive on what their goals are, what their concerns are, where they feel their risks are. And if they are looking to avoid their family having to go through probate, if they are perhaps looking to protect the value of some of their assets from the cost of long-term care, or, they're fortunate enough to have accumulated some wealth during their lifetime, and perhaps they have a taxable estate in Massachusetts, and they're looking to minimize those taxes, then trusts can help accomplish all of those different things depending on the circumstances.
How does power of attorney work in practice? What kind of decisions does it allow someone to make, Erin?
So a power of attorney gives a trusted individual authority to make legal and financial decisions for you. A power of attorney should be really comprehensive. I've seen lots of powers of attorney that are 1 or 2 pages long that kind of just say, this person can do everything for me that I can do for myself. But unfortunately, that really doesn't cut the mustard anymore. You need to be explicit about the authority that you are giving that person. So, for example, the ability to bank on your behalf, open accounts, handle your life insurance, make sure if you're of retirement age that your required minimum distributions from IRAs or 401ks are being taken on time. So you really need to spell all of those things out. And it's important to have not just a primary individual named, but also at least one backup agent. Especially for married couples, it's really common for spouses to name one another in that primary role. But if you are in a common accident, for example, your spouse might not be able to make those decisions for you. And if you don't have an alternate named, your document isn't going to be useful. So you want to make sure that you have an alternate named in your document. And having a really comprehensive power of attorney is going to keep your loved ones out of the probate court in needing a conservatorship. So if you lose capacity, again, by accident or illness, and you don't have a power of attorney, no one just automatically gets to make decisions for you, not even your spouse, not your children. There's no relationship that you have that automatically gives that person that authority. So they would have to go in and petition the probate and family court to become your conservator. That's expensive, it's time consuming, it's public. And when you're in crisis like that, you want to avoid as many legal hurdles as possible. So having that really good power of attorney will help streamline things for you.
So what decisions are handled through, healthcare documents, and how are those different from financial decision making?
So that's kind of the other side of the coin. So the healthcare proxy is going to empower someone to make medical decisions for you. So, does someone need to have surgery? Are there certain types of medications that they might need? Are they in a situation where it's really not safe to be home anymore? And now they need to be transitioned to a different living environment, whether that be assisted living or a long-term care facility, or do they need rehab, things like that. So the healthcare proxy governs the medical decision-making side of things. And again, you want to have a primary agent named, you want to have at least one alternate named to make sure that if something happens, you have some layers of agents in place who can step in for you. And just like with the power of attorney, if you lose capacity and you don't have a healthcare proxy, your family again now has to go in, not to become your conservator, but to become your guardian. That is who the court says gets to make medical decisions for you if you couldn't make them for yourself. And again, it's expensive, it's time consuming, and that both of those court processes can almost entirely be avoided if you have good, thoughtful foundational documents in place.
Wow. So what tends to happen when someone has a will but doesn't have the other pieces in place that you mentioned?
Well, again, most of the time your family is going to end up spending thousands of dollars, months in court, at a time where they would really probably much prefer to be spending that time with you. You've got the emotional turbulence of a loved one losing capacity. And as great as my office is and my team is, I think, they don't want to be spending time with us. They want to be with you. So making things as simple for them to step in and manage things is really important. And also just having a really open dialogue. When someone else has to step into your shoes, that's hard enough. If they have no awareness of what your wishes are, what your assets might be, it makes it that much more difficult for them to step in and handle things in a way that you would want them to. So I really encourage our clients to talk about their planning because that's going to give them the best chance of having their wishes be honored.
So can you share an example of a situation where having the right documents in place made things much easier for the family?
Absolutely. I was just on the phone with a past client recently whose mom and stepfather both ended up in long-term care facilities. Stepdad has passed, and mom has lived another 9 years beyond that, surprisingly. She's in her 90s now. And her daughter was just saying how seamless it was to have to go through all of these transitions as their parents aged by having these documents. They had the power of attorney, they had the healthcare proxy, they had an irrevocable trust to protect the home, so that didn't have to be sold. So it really makes things much easier for your loved ones to have to handle if you have those critical documents in place. Again, otherwise they're kind of tripping over themselves trying to figure out what you would want. What's the best thing to do for you? And not everyone might agree on what that is.
Right.
So you want to choose someone who you think is most aligned and most likely to follow what your wishes would be. You're not guaranteed to have that happen if you haven't taken the time to plan it for yourself.
So, Miss Erin, how do you walk someone through deciding what they need to do, right now versus, it can wait or maybe do it later?
It really depends on their goals. So when we sit down with families, we are talking about primarily what their goals are, what their concerns are, and what their level of risk adversity is. So again, as a basis, those foundational documents are critical to have. And then we're talking about, are they wanting to avoid probate? Are they in a position where they have some assets that they might want to protect from the cost of long-term care? And how quickly they want to address those concerns. So again, foundational documents, to me, no-brainer. You've got to get those in place. And then whether or not you want to address those other concerns depends on how quickly you want to mitigate that risk. When we meet with clients and clients engage our firm, we invite them in every year for a free 3-year review meeting. So that's an opportunity if they are not quite sure what they want beyond those foundational documents. That's an opportunity for them to readdress those concerns a little bit further down the road. So, each person, each family is going to be different. Even if on paper their assets kind of look similar, what they want to happen with those assets, what they want to happen in their retirement years can vary wildly. So we really just dig into what's the hot topic right now? What are you the most concerned about? And what recommendations do I have to get you where you'd like to be?
And to put a nice little bow on this, how does having a complete plan in place change what families deal with later on, Erin?
It takes the stress level from 100 to almost 0. There's just so much overwhelm when you are assisting a loved one who has an illness, who is facing incapacity, that the more direction you can provide for them, the better. And frankly, working with our office, goes a long way. We're fortunate that we have a really good reputation in our community and with our clients, and we're there for your family. So if they find themselves in a situation where they're not sure of what to do next, or this situation has happened, is there anything that we need to be doing? They feel comfortable calling into us. They know that they're going to get good, reliable guidance from us. And that really makes a huge difference for families.
Well said, Miss Erin. Thank you so much for your time.
You're very welcome.
Right. That's it for today's episode of Ducks in a Row, the Estate Planning Guide. If you'd like to learn more or speak with Erin and her team, you can visit myfamilyestate.planning.com. Thank you so much for listening. And don't forget to subscribe, share the show, and leave a review so more families can get the guidance they need. We will see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.